Yes, the
after
supplementary.
hearing.
Supplementary.
Yes.
Yes, you want some accommodation?
Accommodation, if possible, that is what we prefer. But
What is your prayer?
my prayer is that since my friend is there, I don't know what he is.
My lord, pleadings are completed. This has come in admission, so it can be fixed for hearing.
At the admission stage?
Yes, my lord. And after vacation, it would be convenient for me, my lord. 22nd,
I have 4 admissions, so can you wait? Then I can.
Yes, my lord. Yes, my lord.
I'll have a look at the file and pass it.
After the admission, it will be.
That is how the sequence is. All the supplementary probably after the admission.
No, my lord. In principle, see.
No, here we'll do that. You wait.
Yes, my lord.
Yes. Call these supplementary admissions after the main admissions are over. Yes.
For admission, item number 1.
Your Lordship,
Mac appeal.
yes, my lord. I'm appealing on behalf of my senior, Mr. Rosal Subedi. And my lord, as per the office note,
Has this come up for the first time or no? Notices were issued.
yes, my lord.
AD cards, unserved notice. But this is a Mac appeal.
Yes, my lord.
Why is it not admitted? It's a statutory appeal. Isn't it?
Yes, my lord.
Who are you appearing for?
Lordship, I'm appearing for the respondent number 1, who is the claimant in.
I'm admitting this appeal. It's a statutory appeal. In the meantime, how many respondents are there?
5, my lord.
5, and you are for 1.
I'm for 1, madam.
Heard, Mr.
Ramon Marante.
So and so, learned counsel for the appellant. Stop. Also heard, Mr. Johnny L.
Benjamin, madam. Benjamin.
Mr. Benjamin, learned counsel for respondent number 1.
Number 1.
Stop. This is an appeal under section 173 of MB Act 1988 against the impugned judgment and award dated 8/12/2022 passed by the learned member cum presiding officer of Motor Accident Claims Tribunal at Aizawl, Mizoram, in MACT case number 47 of 2019. MB Act. The statutory deposits have been deposited.
Yes, my lord, we have already deposited.
Deposited?
Yes, my lord. It was reflected in order dated 15 May.
Yes. The statutory deposits in terms of section 173 of so and so had already been deposited before the registry of this court. Admit, issue notice, returnable 4 weeks. Since Mr. Benjamin enters appearance on behalf of respondent number 1, no formal notice, extra copies within the course of the day. Stop. Registered post with AD in respect of the other respondents. List after 4 weeks on a date to be fixed by the registry. Case records required. It's a message. It will be required. Case records from
MACT Aizawl.
Yes. MACT Aizawl. We call for. Mr. Benjamin did your part. You should have said all that. Anyway, but Mr. Lalaram Jaba, I have noticed here statutory appeals are not being admitted. Statutory appeals should have been admitted. Yesterday also, regular first appeals. I find notices are being issued and it is going on. So these are statutory appeals. Anyways.
Item number 2.
Yes, Ms. Valentina. Contempt first day.
My lord, yes.
Notice is issued.
Yes, my lord. My lord, if I may. My lord, in my humble opinion, there is no case, the case can be closed at this stage because there is no contempt in the matter.
The order?
If I may take your lordship kind attention to page number 25, annexure 9 of the contempt petition. Contempt petition, page number 25, annexure 9.
One second. Contempt petition, there is no 25.
Contempt petition is
The last page is 15.
really, my lord, in my
Are you referring to the order dated 17/8/2022? Is that the order?
I'm referring to
There's at page number 13 of the contempt petition.
Yes, that's the operating part, correct?
My lord.
I think it's page 13, para 7. Ms. Mary?
yes, but its pagination is a little bit different in my
Anyway, you read if
yes.
you have it.
Anyway, yes, my lord, the relevant portion which I would like to read out is in the last portion. It starts with in view of consent of the parties. In view of consent of the parties.
I don't have that. Where are you reading from?
Page number 2. Page number 2.
No, page number 2 of the which judgment, Miss Mary? Are you holding the same brief?
Yes, my lord. I will just try to. Yes. I will just try to.
Which is the order?
Yes.
Order page number 13, my lord.
13, right?
Yes.
Just read para 7, Miss Valentina.
Yes. Paragraph number 7. In view of the above.
Yes, yes.
1 second, Miss Mary. Yes.
In view of the above, the Chief Secretary to Government of Mizoram, Respondent number 1, shall constitute a verification team consisting of the Chief Engineer Road, Public Works Department, Respondent number 4, or his representative. The Director, Land Revenue and Settlement Department, Respondent number 6, or his representative, and the Deputy Commissioner cum District Collector, Respondent number 8, or his representative, who shall verify the claim of the petitioner in the presence of the petitioner within a period of 1 month from the date of receipt of a certified copy of this order. Paragraph number 8. The verification team consisting of the above persons shall verify whether the land of the petitioner has been used by the respondent number 3 and 4 for construction of a public road. If the answer is in the affirmative, the respondent shall, within a period of 1 month from the date of the site verification, take a decision as to whether they want to permanently acquire the said portion of the land of the petitioner. If the answer is in affirmative, the state respondent shall make a requisition for acquisition of the land as per law. Paragraph number 9. In the event the state respondents are not willing to acquire the land of the petitioner, the respondents number 3 and respondent number 4 shall stop using the petitioner's
This
Uh,
land.
is not done. The verification has been done or not done?
Verification had been done, my
Has been
lord.
done.
Yes.
And what is the report? Where do I get the report?
In the show cause reply of the affidavit filed by the respondents, my lord.
Yes,
However,
which page?
yes, my lord. But before that, my lord, if I would like to have your kind attention.
I'll give you full time to argue, but I just want to
Yes, my lord.
know what is the case. So if verification is done, what is the report? Let's go to the report first. Spot verification. I think this is a lecture 6. Yes, you may read, Ms. Valentina.
Site verification report.
Read from what?
GLSC number 42 of 1980. On examination of the land pass, there was no depiction of an existing jeep road. However, an examination of Google Map on the same location of the year 2010, the map clearly shows an existing road at this location. The photographs of the Google map for 2010 as well as for 2023 showing the roads then as well as the present conditions is attached as Annexure 1A and Annexure 1B. Moreover, statements from the local council chairman of Ramthar North and Trump is stating that there exists a jeepable road prior to 2010 are attached as Annexure 2 and 3. The length of road passing through this plot of land.
They are doubting the ownership. The last paragraph, in view of the observation, I'm sorry, I read it a little fast. They're doubting your ownership, correct? In view of the observation of the site verification team, as mentioned above, the claim made by the petitioner in view of so and so and so and so are highly suspect and cannot be entertained at this late date. For claim regarding so and so, has stated that he personally visited so and so and got her consent and signature for a document stating that she consented to the widening of the road. However, this document cannot be located. The department stands on the ground that the work for construction of the road was done with consent of landowners and no illegal action was committed by the PWD. So, Ms. Mary, the report indicates that the persons who are claiming their land has not been acquired. They have some other land?
No, but what happened is that they have stated that the PWD department have damaged their road and constructed the road in her land. But then the story, from our side, the government officials, when they have done the spot verification, they have stated that she has consented to that. And my lord, moreover, we do not need to go into that. Because here, yes, it's contempt. And then as per the direction
whether the direction of this court was followed or not followed, that is the only thing.
Yes, correct. To conduct a joint verification, if it is in the formative, but now this is not in the formative. Now the course that they have to take, if they do not agree with the spot verification report, is to approach the appropriate forum, not in this contempt, before the contempt court.
Yes.
But my lord, here the direction is only to conduct a spot verification down to the
Yes,
conduct.
Ms. Valentina,
Spot verification was
it
conducted.
appears that the verification has been done.
Yes, my
That
lord.
means the order of this court has been complied. The report may not be in your favor. You have other remedies available.
My lord, I would like to submit that verification has been done. However, the whole order is not being complied with because at paragraph number 8 and 9, direction was given to the respondents to follow certain steps, my lord. If they are to acquire the land, they are to make the requisition as
No,
per.
but
If it is in affirmative,
that
it is not in affirmative.
that depends on the result of the verification.
Yes, my lord.
The
However,
verification is against you.
but my
The
lord,
report
I
of the
was,
verification. So after that, there requires nothing to be done. Let's go back to the order, page 13. Yes. The verification, paragraph 8. The verification team consisting of so-and-so shall verify whether the land of the petitioner has been used. Correct. Now the report is that your land has not been used. If the answer is in the affirmative, then what is to be done is given. But here the answer is in negative. Are you following what I am saying?
yes, my lord.
So I am not saying that the report is correct or not correct because I am not looking into the legality of that report. You have your remedies. You may not agree. But what I am concerned is whether the order of this court has been followed. That's all. Right? Now here it says if the answer is in the affirmative, the respondent shall within the period of 1 month from the date of the site verification take a decision as to whether they want to permanently acquire so and so. You are saying this has not been done. But here, after the verification report, the answer is negative. So there is no requirement for the state authorities to do anything.
My lord.
Have you followed?
Yes, my lord. However, I would also like to submit that certain new facts has arrived in this instant case, my lord.
New facts and contempt case, how can I go?
Yes, that is not allowed at this stage. They should
Sorry,
yes.
Valentina, the court's order appears to have been complied.
My-
And most important is that in contempt cases, it is between the court and the contemner.
Yes, my lord.
You have a very limited right. Your right is to bring it to the notice of the court that such and such order of this court has not been complied. And thereafter, it is between the contemner in the court. Now here we have seen that the verification has been done and it appears it is in the negative, so it appears nothing much to be done.
My lord, I would also like to submit that the respondents, necessary respondents number 13 and respondent number 8 have not submitted their affidavit
That's not necessary.
because the
Not
order has been
necessary.
directed towards them. my
Because
lord.
the order, the report is there, it has been brought on record by the other contemner. All right, anything else?
Yes, my lord.
I am
mean-
asking this because sometime from that side I'm told I have not heard. So that is why I'm asking. Anything more? Because I'm dismissing this.
No, my
don't
lord.
find
I
it.
would like to take 1 week's time.
No time. What time the order of the court has been already complied. All right, take down. Heard MS Valentina, learned counsel for the petitioner. Stopped. Also heard MS Mary so-and-so, learned counsel appearing for respondent number. Miss Mary, respondents.
For respondent number 1, 2, 3, 4, 9, 10, 11, 12, 14, and 15. I will repeat, my lord. 1 to 4, 9 to 12, 14, and 15.
Got it. This application is filed under Rule 9 of the this application is filed under Rule 9 of the Contempt of Court Rules 1977, read with Section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, for initiating a contempt proceeding against the respondent's contemners. Stop. It is the case of the petitioner that the order dated 17/8/2022 passed by this honorable court in WPC number 128 of 2021 has been willfully and deliberately not complied with, and accordingly the instant contempt petition has been filed to bring to the notice of the court such disobedience. Stop. MS Valentina so-and-so, learned counsel for the petitioner, submits that in terms of the order dated 17/8/2022, the respondent authorities firstly was required to conduct a spot verification to find whether the length of the petitioner was acquired. It further appears, she further submits that if the answer is in the affirmative, the order further lays direction to be followed in this regard. Stop. MS Mary so-and-so per contra submits that the order dated 17/8/2022 passed by this court stands complied, and therefore no case of contempt is made out against the respondents. Stop. She further submits that the verification as directed by this court by order dated 17/8/2022 has already been done, and it has come and it has been reported that the length of the petitioners has not been acquired for the subject project. Stop. Correct, Ms. Mary?
Yes, my lord. Joint verification as directed was conducted on 21.
All right, I'll take that. Just one second. Heard and perused, you put that paragraph, and then you say paragraph 7, 8, and 9 of the judgment of the order dated 17/8/2022 is reproduced hereunder for ready reference. Reading of the aforesaid judgment indicates that this court directed this court constituted a verification team in order to construction of a public road, comma, the respondents were directed to take a decision as to whether they want to permanently acquire the said portion of land of the petitioner, and if the answer is in the affirmative, the state respondents were directed to make a requisition for acquisition of the subject land as per law. Stop. It further appears that this court further directed that in case the state respondents are not willing to acquire the land of the petitioner, comma, the respondent number 3 and respondent number 4 shall stop using the petitioner's land and shall verify and assess the damage caused to the petitioner's land within a month from the decision taken by the respondent number 3 and 4. Stop. Respondent number 11 has filed a show cause reply on 6/8/2024, wherein it is stated that pursuant to the notification dated 29/9/2022, a team consisting of the following members conducted a joint verification on 21/10/22 at 12 noon in compliance with this Honorable Court's order dated 17/8/2022, passed in WPC 128 of 2021. 1, 2, 3, 1, 2 and 3. Can we get the names at page 3 of this, of that show cause I'm putting up? It further appears that it is further stated in the said show cause reply that the said spot verification team were accompanied by the following officials: 1, 2, 3, 4 and 5. Same page. Reading of paragraph 5. No, not reading of paragraph. Paragraph 5 of the said show cause reply is reproduced herein for ready reference. Okay. Paragraph 5, A to A, from page 3 to page 6. Paragraph 5 and paragraph 6 also. Paragraph 5 and paragraph 6. 6. The reading of the aforesaid report, sub-enclosed as Annexure 6 to the said show cause reply, appears that the land of the petitioner was not acquired for the subject construction. Stop. Hence, stop. In view of the above, it appears that the order of this court dated 17. What is the order date? 17?
8/2022.
8 so and so stands complied. Therefore, stands complied. Thus, thus the contempt petition stands closed. Allowed. Dismissed. Sorry.
No, Mike.
Item number 3. this case, I have received a counter affidavit filed by the.
You want to file a reply?
Yes, my lord.
All right. As prayed for by Mr. So and so, learned counsel for the petitioner,
Legal aid counsel.
legal aid counsel for the petitioner,
Yes, my lord.
representing the petitioner, seeks 2 weeks' time to file rejoinder to the affidavit in opposition filed by the
State respondent.
state respondent. Stop. Prayer allowed. List this matter after 2 weeks on a date to be fixed by the registry. 2 weeks or 3 weeks?
3 weeks, your lordship permits.
3 weeks.
Right. Item 4.
So,
My lord, is noted.
no, not why are you calling the order? Call an admission from supplementary. Yes, Mr. Lamra, Baba,
13 and 14. Also.
13 and 14.
13 with 14.
13 with 14. Yes, you were saying something.
Yes, my lord, pleadings are completed. So,
So you want an admission hearing.
yes, my lord.
What is the matter? In short, what is the issue?
Your lordship, it's regarding non-payment of interest and solution in respect of the lands acquired.
It appears, heard Mr. Lalram Zuawa, learned counsel, appearing for the appellant.
Yes.
Senior counsel assisted by Mr. So and so for the petitioner and Mr.
P. Goswami.
P. Goswami, learned counsel, appearing for respondent number
5.
5 and MS Sangpui for
Respondent number 4.
respondent number 4 and Carolina, right? submitted at the bar that the pleadings are completed and the case can be disposed of at the admission stage. Accordingly, list this matter for admission hearing on
My lord, if there is no inconvenience, 22nd of October.
22nd. Subject
is-
to you all. If you all are agreed, I will fix it on 22nd.
We'd like to have it earlier, but since
Yes, yes.
it appears that he is having some difficulty,
I have some personal difficulty, my
No
lord.
problem. 22nd October then. 22nd 10 2024.
My lord, same order for both the cases.
Yes, yes. It's with 13 and 14. Huh?
Orders, item number 5.
Lalram Yanga, the
Yes.
service is complete.
Yes, my lord. And scanned copy of the LCR is received. I think paper book will be required, my lord.
Admitted.
Admitted already.
You are appearing for the
Respondent, my lord.
sole respondent.
Yes.
Mr. Your name?
Archival something.
So and so enters appearance on behalf of the sole respondent. Stop. As such, service stands complete. It appears that the scanned LCR has already been received. Let registry prepares paper book.
Yes, my
Let
lord.
registry prepare the paper book and furnish the same to both the councils.
Which of which?
List after 4 weeks on a date to be fixed for the registry.
Item 6.
68 days, Mr. Joseph.
Yes, 68 days, my lord.
Serious objection.
My lord, we'll have to file a written objection, my lord.
Why written objection for 68 days? What is the ground?
So, my lord, the grounds are mentioned from paragraph. In short, my lord, firstly, the client is an old man, my lord. So when the judgment and order came out and information was given to him, my lord, because he was not in a position to move out of his
79 years old.
79
He has lost his youthful soul.
mobility and all of those things. That's the first one. So when he received the order, by the time he received the order, he consulted his family. And then after they made a decision, they engaged the present councils. And we shifted our office, my lord. And as a result, we could not immediately work on the appeal. And by the time we finished the moving,
Mr. Pautu,
my lord,
what objection?
irrespective of the fact that the councils were like, the judgment and order was rendered on 8/9/2023.
On 8.
9/2023. And my lord, the steps for appeal was taken on December. So, my lord, there was an ample time for the appellant to consider whether he would be appealing or not. So, that is one. And it is not a case that he has engaged another counsel, my lord, given the fact that the same could have given him the fact that there is a time limit for filing this appeal. So, my lord,
You see, in every cases of a condemnation, some lapses is always there. Now the question is whether that's deliberate and willful. That is the question. Otherwise, it's a positive discretion which has to be exercised, isn't it? So,
there was 27 days vacation in between also, my lord. So, it became 41 days after his vacation.
I can condone the delay now. I have heard you. I'll deal with your submission unless you want to. Because I don't see anything that to be required to be put through an affidavit. You have already got notice,
I have received.
isn't it? And you have entered appearance. So that is your objection.
That is my main objection.
That they had ample time to contact a council and take positive steps for filing the appeal.
On the part of the council as well, my lord, the steps could have been taken.
No, but when, Mr. Joseph, when did the applicant contact the lawyer?
So, my lord, it's written.
Para 6.
Yes. Paragraph number 6. Then immediate
Here, after he had received, he took some time to consult his family
members, yes.
to decide on whether he should file an appeal against so-and-so.
On 11/12/2023.
After he finally consulted, he instructed his counsel on 11/12/2023.
Yes, madam.
So it took about 2 months to take a final decision.
Yes. Yes. Yes.
Because when he first received this order, he received the order on 22/9/2023. He has around 2 months.
That is where, what is the objection? They're saying, what is this decision that he was taking for these 2 months?
Yes.
One is expected to be vigilant, prudent for pursuing the remedy in law, correct?
Yes.
Now, only thing, this gentleman appears to be 79 and appears that he is not keeping well.
Yes.
This is the ground. Mr. Pautu?
My lord, in fact, 3 months have elapsed, my lord, not 2 months. 3 months have elapsed. September, date of judgment. And
No, then there was some winter vacation.
winter vacation, 41. So after deducting the winter vacation, it has become 41 days.
The council also have taken some time.
Yes.
All right. Item 6. Heard Mr. Joseph so-and-so, learned counsel for the applicant. Stop. Also heard Mr. Lal Rokunga Pautu, learned counsel for the respondent.
number 1.
Only sole respondent.
No, there are 2 respondents.
They have, what about them?
So there are 2 respondents and they are both represented.
Represent.
Yes, he's representing both of them.
I am representing only one. Respondent number 1.
Are you sure?
Yes.
Mr. J.H. Ramney Moya was here, my lord, the entire time. I don't know where he vanished.
Mr.
J.H. Ramney Moya.
Okay, so there is a counsel.
Yes.
Though the name of the learned counsel appearing for respondent number 2 is reflected in the cause list, comma. However, he is not present when the matter was called. The instant application is filed under Section 5 of the Limitation Act 1963, read with Order 41, Rule 3A of the Code of CPC 1908, for condonation of delay of 68 days in filing the connected appeal petition against the impugned judgment and order, as well as decree dated 8/9/2023, passed by the Senior Civil Judge 3, Aizawl, Judicial District, Aizawl, in civil suit number 37 of 2016. Mr. Joseph so-and-so, appearing for the applicant, submits that a delay of 68 days has occurred in filing the connected appeal, filing the accompanying regular first appeal.
Yes.
For reasons beyond the control of the applicant. Stop. He further submits that since the applicant is an elderly person and not and having mobility issues, took some time to take a decision as regards the filing of the appeal, and after he had consulted his family members and have taken a decision to file the appeal, he had contacted his lawyer. However, the engaged lawyer, as was moving his chamber, also in this process some time has been spent. Stop. He accordingly submits that the explanation tendered by the applicant are sufficient for condonation of delay. Per contra, Mr. Lalrukunga Pautu, learned counsel for the respondent number 2,
Respondent number
1, submits that there was ample time available for the applicant to sitting for almost 3 months, silent, is not silent, warrants no positive discretion from this court. Stop. Right?
Yes, my lord.
Then I have heard the submissions made by, I have given prudent considerations to the submissions made by the learned counsels for the parties, and have perused the grounds for condemnation averred in the interrogatory application. Stop. Paragraph 5 to paragraph 8 is reproduced here under for any reference. Okay? Reading of the aforesaid paragraphs appears that the applicant, being an elderly person and having lost his mobility, and after being informed of the passing of the judgment and order on 9/9/2023, he could only manage to meet his counsel on 22/9/2023 and receive the impugned judgment. Stop. It further appears that after he had received the said a copy of the impugned judgment, he consulted his family members to decide on the next course of action, and after consulting his family members, he instructed his counsel to file the appeal on 11/12/2023. It further appears that after the instructions for filing appeal was given, the counsel applied for the certified copy and received the same on 15/12/2023. Stop. It further appears that thereafter the courts in Mizoram was closed for winter vacation from 16/12/2023 to 11/1/2024, and after the reopening, the engaged counsel was shifting his office to a new address for which some more time had occurred, and ultimately the appeal was filed on 12/2/2024, by which date a delay of 60 days has occurred. 68 days has occurred. Stop. The reference and M. Balakrishna's case from the earlier order, just put that, and after that you said, in view of the above, the explanation appears to be satisfactory and sufficient. Stop. Accordingly, the delay of so and so days stands condoned. Sorry. RFA registered?
Registered, madam. Obliged, madam. Item number 7.
120 days.
Yes, my lord.
First time.
Yes.
Notice?
No notice, mas. You have to issue the notice from today.
Mr. Joseph, the main case, then I will ask to, it's an RFA. With an RFA, I think I can admit it. It's a statutory appeal. 1 second, Mr. Murmu. 1 second. Wait. I'll admit it then.
Yes, madam.
Heard Mr. So-and-so for the appellant and so-and-so for the respondent number
Respondent number 1.
1. This appeal is presented Civil Judge 2, Aizawl District, Aizawl, stop. Admit, issue notice, returnable 4 weeks. Since Mr. So-and-so enters appearance on behalf of respondent number 1, no formal notice, extra copies within 3 days from today.
Respondent number 2 is also represented, my lord.
And he is not here.
He's not here today, yes, I will serve.
Notice by registered post AD in respect of R2. Records also will be required.
Records
From the court of
Senior Civil
so
Judge.
and so, from the court of Senior Civil Judge 2.
Yes.
We call for list after 2 weeks on a date to be fixed by the registry.
Match number 7.
Yes.
Yes, my lord.
First day. Okay. Heard Mr. M.
Ram Murmu.
Ram Murmu, counsel for the applicant. Stop. This is an application seeking condonation of delay of 120 days in filing the accompanying regular first appeal. Stop. Issue notice, returnable 3 weeks, 4 weeks.
4 weeks.
4 weeks. Steps by registered post AD, list after so and so.
Item number 8.
Impleadment, Mr. Malhotra.
Yes, Your Honor.
Notice has been issued.
This is the first time.
First time. So notice has to be given, or you are appearing for whom?
Respondent number 1 and 2, my lord.
How many respondents, Mr. Malhotra?
3 years.
This is new incumbents.
Yes.
New incumbent.
Yes.
I could have. I think I can dispose of
Yes,
because
can be disposed. I don't have any objection, my lord.
correct. All right. So the new incumbents are mentioned in paragraph 2.
Yes.
Heard Mr. A.R. Malhotra, learned counsel for the applicant. Stop. Also heard Mr. So and so, learned counsel appearing for respondent number 1 and 2. This is an application seeking impleadment of Mr. J.H. Lalbhai Kliana, the new incumbent to the post of Chief Executive Officer, Mizo Khadi and Village Industries Board, new capital complex, Hatla, Aizawl, as respondent number 4 in the connected contempt petition. Contempt case C, number 9 of 2024. Stop. Mr. Malhotra submits that since the proposed arraigned respondent is the new incumbent to the subject post, his presence is essential and necessary for the effective adjudication of the contempt petition. Stop. Mr. So-and-so, representing the respondent number 1 and 2, fairly submits that he has no objection to the prayer of the said impleadment. Stop. It appears that the impleadment sought is essential and necessary for the effective adjudication of the contempt petition. Accordingly, the impleadment application stands allowed. As such, it is provided that Sri J.S. Lalbhai Kliana, Chief Engine Executive Officer, Mizoram Khadi Village Industries Board, be arraigned as respondent number 4 in the accompanying contempt case. Allowed. Let amended cause title be submitted before the registry for doing the needful in the contempt case. And in the contempt case, you say issue notice to the newly impleaded respondent number 4 by registered post 80. Steps to be taken within a period of 3 days from today. List after search.
Similar order in item 9 also.
Similar?
Item 9.
Okay. What disposed of?
same,
All right.
same person.
All right, Mr. Malhotra.
For the
There
item
is
number
a
10.
contempt case.
My lord, the translation is, this is the translation.
All right. Any authority on LTCPC?
So, my lord, in this case,
27, Rule 27.
Rule 25, my lord, your lordship had mentioned. So, in that, what I have found is the full bench judgment.
LT. Dina.
This is a full bench judgment of the Rajasthan High Court, my lord. They have discussed at length about the issue in this case, my lord, this similar kind of case. Now, what they have stated, my lord, is that, as your lordship had rightly pointed out, if there is an issue which has not been decided, but the evidence is there, under section 103, this court can decide the facts. That's one, my lord. But if the issue is not decided, and the facts are not there, then the court can resort to Order 41, Rule 27.
Yeah, because here I find
Yes.
it is not there.
It's not there.
It is not there.
Yes. And Order 1, Rule 41, Rule 27, my lord, there are two options which are available to this court as per this order.
Yes.
One is to remand it to the first appellate court. And the second is to remand it to the original court.
Original.
Now, the problem with remanding it to the first appellate court, my lord, is because the appellate court is already an appellate court. So then this court will not be able to go into the facts again. That's what this judgment says. There are disputed judgments on this in this respect. The Guwahati High Court in 1956, my lord, went into the facts even though the first appellate court decided on the facts. Anyway, my lord, the second option, if it goes to the original court, this court can again see if the finding of that original court is correct or not on the facts. So my humble suggestion, my lord, if your lordship decides to remand, it should be remanded to the original court and not to the first appellate court. So that is.
I was also thinking of sending it to the original court.
Yes, yes,
Because that entire issue
yes,
has not been touched.
yes,
And it will not be fair to either of you
yes,
if it is not sent there. Because there both parties will get the chance. You both can adduce your evidence. The wife, she can show how her husband got the title.
yes.
Whatever is there, if there are witnesses, the witnesses will be brought. You will get a chance to rebut and to your plea. That perhaps will be a better course. Right?
My lord, in that regard, what I am thinking is, in my humble opinion, will it be appropriate to send the matter by directing for fresh trial under the heirship certificate? Because the issue is with regard to the legality of the transfer of the ownership in favor of the husband.
See, fresh trial about the heirship, then again everything will go back for everything. Here now it appears while deciding the entitlement of the plaintiff applicant for the heirship certificate, the court did not look into her predecessor's right, because that was objected, title. That was objected. That is the problem.
That is correct. It was objected, my lord. But
That limited, if we send, because then I think things would move a little faster.
Yes.
Otherwise, you go back for a retrial.
First appeal, the
Again,
second appeal. Yes.
whoever, there is always a possibility that one side will carry it to the first appeal,
Yes.
and from there to the second appeal stage. So matter will further get dragged for a few more years. But here, once we get the report back, the decision after the trial, retrial on the new issue, we will have that part of this record and this court will take its call.
Usually, my lord, when the heirship certificate was filed before the trial court, what the trial court is to consider is the entitlement of the petitioner with regard to that
Alright, I'm
property.
posting this matter tomorrow. Hearing concluded. I'm taking it as concluded. I'm posting it tomorrow for the purpose of dictating. I don't want to reserve it because it becomes difficult. I'll dictate it here. Tomorrow?
Certainly, my lord. Obliged, my lord.
This giving in the chamber, huh?
Item 11.
Tell them this is for tomorrow. But I will send it by a slip or listing. I need the CPC. Yes, that rental matter.
Yes, your lordship.
It's Mr. Miller's turn, or you have you're still to finish. I
Yes,
forgot
my
it.
lord.
It's still to finish.
Is still to finish?
Yes, my lord.
Yes. Yes, Mr.
Your
Lal.
Lordship, if I'm allowed to read the short judgment, this is an ex parte decree, my lord, ex parte judgment.
So this is first appeal, right?
First appeal, my lord.
So what are the points involved?
The points involved is that the present respondents 1 and 2, they had been illegally occupying my land.
Number one,
Yes. Number 1 and 2.
first point,
First point is that I have a landed property covered by the registered LSC within Lai Autonomous District Council, Longklai.
you are the plaintiff.
I'm the plaintiff. I was the plaintiff in the trial court, my lord. And my land was illegally occupied.
Illegally and forcefully.
Yes, illegally and forcefully occupied by the respondents number 1 and 2 with effect from January 2012.
With effect from
January 2012.
January 2012.
Then, my lord, despite asking them to vacate the land, they failed to do that. And I asked for the rent, that was also not paid to me. And despite giving of the legal notice, and it wasn't complied with, so I filed that money suit. I filed this money suit in the year 2021.
So second point will be, first is whether the land of the plaintiff was illegally and forcefully occupied.
Yes.
If the answer is yes in the affirmative,
My lord.
then
The question of payment of rental compensation
Whether-
will come.
plaintiff is entitled for any rental compensation.
Exactly.
Right, Mr. Miller? I think these are the 2 points
It's all
to be determined,
exactly.
because while I authored the judgment, I will have to first set up the points of determination. That is what I am required to do, isn't it?
Yes.
Yes. 31. The judgment of the appellate court shall be in writing and shall state the points for determination, the decision thereon, the reasons for the decision, and so these are the 2 points involved.
Yes, ma'am.
Yes. Now, tell me, what is there to show that you are it is your land, number
Yes.
1. Secondly, that they have illegally occupied it.
Yes.
Yes.
So, my lord,
Which part of the evidence?
yes, my lord. I'll just come to page 51. In the meantime, my lord, I may submit that the present respondents, they failed to file their written statement, and thereafter ex parte proceeding was drawn. My lord.
So, in the
trial court proceeded under Order 8 Rule 10.
Ex parte.
Yes.
Order.
Order 8 Rule 10, CPC.
10. Yes.
But instead of directly pronouncing the judgment, then evidence were invited. So I had produced 2 plaintiffs' witnesses before the trial court.
Let's go to order 8 once. Order 8 Rule 10.
Order 8 Rule 10. Do I need to read, madam?
No, it's all right. Or make such order in relation to the suit as it thinks fit.
Yes, madam.
Yes.
So on that ground,
So then
evidences
evidence
were
were
invited.
called.
Yes, called. And
So
page
you have given evidence of
evidence
two
of the
witnesses.
2 witnesses.
Yes.
The plaintiff himself, as well as another witness, madam.
Yes. Yes.
So may I come to page 50 of the paper book?
Yes.
This is the judgment, the portion where evidences were appreciated, madam.
Yes.
Page 50, the last para.
Yes.
I may read, Your Lordship.
Yes, please.
Para 3. The plaintiff and his witness, namely Lal Vensama, son of so-and-so, resident of so-and-so, submitted their examination in chief on affidavit. The plaintiff reiterated what he had stated in the plaint. He had exhibited photocopy of his LSC number so-and-so, photocopy of tax payment receipt, copies of photos showing the houses constructed by the defendant number 1 and 2 and stones, boulder rocks stocked on his land by the defendants number 1 and 2. Photocopy of legal notice served to the defendants number 1 and 2.
You had exhibited the LSC.
Yes, my lord. And along with
Show
the...
that it is yours. And then photographs showing constructions.
Yes, my lord.
Yes.
And other boulder rocks stocked within his land.
Yes.
Photocopy of the legal notice served to the defendants number 1 and 2, and photocopies of acknowledgement of legal notice duly received by the defendants 1 and 2. The plaintiff's witness named Nilal Vensama, son of so-and-so, resident of so-and-so, had stated in his examination in chief that he is the president of village council of Bungklang South, and that the plaintiff have a piece of land located at Ramrikon, the village boundary point of Bungklang South and named Buitlang village. He further stated that RPS company occupied the land of the plaintiff from the year 2012 till date, and that they have constructed camps, 4 houses, including 1 reservoir, since their occupancy, and also that they have stocked sandstones, boulder rocks, and other construction materials in the plaintiff's land. And number 5 says about the absence of the plaintiff and failure to file their WS, my lord.
Yes.
And page 52 will be relevant, my lord. It's a short sentence. I may read again, my lord.
Yes.
I have heard oral argument of learned counsel for the plaintiff and perused the written argument submitted by him and gone through the case record. In the instant case, the plaintiff prayed to pass a decree declaring the defendants number 1 and 2 illegally and forcefully occupied his land. To enable an order of declaration, the plaintiff must establish the following. Number 1, the right of the plaintiff, that is, the plaintiff is entitled to any legal character or any right as to the property.
This the LSC was given.
Yes, ma'am.
Yes. Then.
And number 2, the infringement, that is, the defendant is denying or is interested to deny the plaintiff's title to such legal character or right. Number 3, the declaration, that is, the declaration sought is that the plaintiff is entitled to such a legal character or right. Number 4, the consequential relief, that is, where the plaintiff is able to seek further relief than mere injunction, he seeks such relief. Point right, the plaintiff had exhibited his land document and his witness has also stated that the plaintiff owned a particular land and that defendants number 1 and 2 illegally occupied the land, thereby infringing the rights of the plaintiff. The plaintiff is entitled to sort for his right. Thus, the plaintiff succeeded in establishing the first 3 conditions. However, the consequential relief paid by the plaintiff is for rental compensation at the rate of 50,000 only per month, which shall be effective from January 2012, and also to pay the area amounting to rupees 54,50,000 only with an interest at the rate of 6% per annum, accruing from the illegal and forceful occupation of the plaintiff's land. The plaintiff did not produce any documentary proof to reveal that there is a rental agreement between the parties. There is no basis for computing the amount claimed by the plaintiff. There is no relationship of landlord and tenant between the parties for the plaintiff to claim for rental compensation. Thus, the plaintiff failed to fulfill the last condition to enable an order of declaration. As such, I am of the considered view that the plaintiff has not established his case with an oral or documentary evidence. Therefore, the instance suit is dismissed.
No, but what are the evidence to show that the defendant number 1 and 2 has occupied and are staying in the land? Only you have stated.
Yes, only.
What is there otherwise?
Even the PW number 2.
Have you stated from which day, how they have stated?
Yes, my lord.
Because why I'm asking from paragraph 8, it appears that it's just a vague assertion on your point that D1 and 2 illegally occupied the land, thereby infringing the rights of the plaintiff.
My lord.
And the order reads like this: the plaintiff is entitled to sought for his right.
Yes.
That the plaintiff succeeded in establishing the first 3 conditions. However, the consequential relief paid by the plaintiff is for rental compensation and also so and so. Probably illegal and forceful occupation. The plaintiff did not produce any documentary proof to reveal that there is rental agreement between the parties. There is no basis for computing the amount claimed by the plaintiff. There is no relationship of landlord and tenant between the parties for the plaintiff to claim for rental compensation. Thus, the plaintiff failed to fulfill the last condition. That means the factum of illegal possession has been admitted.
Admitted.
Correct? Because
Yes.
the first 3 condition was done, isn't it?
Yes, my lord.
Number 2 is infringement.
It was in my favor only.
And there is no cross appeal.
Yes.
There is no cross appeal. So that means it is an admitted fact then.
Yes, and there can be no.
Now the question is only whether rental compensation you are that is. Admittedly, there is no tenancy agreement or a rental agreement.
Yes, it was forceful.
But
my lord, if I may, my lord, my contention is.
You see, of course, right to property is no longer a fundamental right, but it's a human basic right. You cannot be deprived of the benefit of your property.
Yes.
Without being given the rent, anybody cannot just come. But then, do you carry any authority on this? Because that only how to assess the compensation in such a case? Because then, number 1, there is no rent agreement.
Yes.
In absence of rent agreement, but what is admitted is that yes, D1 and 2 has occupied your land.
I'm entitled.
No, that entitlement only I'm asking.
Yes.
Now, if they are occupying illegally, which is established, in that case, is compensation automatically follows?
Yes, it has to be paid, my lord. And that is also agreed by the landed trial court.
You are not even seeking their eviction. You don't want them to leave. You could have obtained the remedies available for eviction. You don't want that.
So, my lord, my point is that despite asking them to vacate the land, if they fail to do so, then so long as they occupy, they have to pay the rent. That is what I was claiming before the trial court. So, my lord, the landed trial court had erred by deciding that there is no rental agreement between us. There is no relationship between landlord and tenant. But how can that kind of rental agreement could be there? Because it is a forceful and illegal occupation. So there was an illegality in the decision, my lord. So there can't be any relationship between that kind of relationship between.
What was the compensation that you asked?
50,000 per month. So that's why, so long as they could not file, they didn't file any written statement, my lord. Then I was asked by the trial court to prove my case. So it was on the basis of my claim that Yes, the trial court says that, yes, the first three conditions, it was affirmative, it was in my favor. But lastly, my lord, it was illegally decided that there was no rental agreement. Then how can rental agreement be made? Since it was an illegal.
I am following what
Yes.
you're saying because it is not that you both have
Yes.
into an arrangement here. They have forcefully occupied.
Yes.
But I am asking how you are so content, how you are so comfortable with this kind of a forceful arrangement. You have not taken any steps to remove him. Neither you are asking anything also in the suit. All that you want is a declaration that it is forceful and a rental compensation, consequential.
Since, my lord, they are the.
Now, how will the civil court determine the rental part that is supposed to have, that ought to have been agreed between the two? And if it is an illegal occupation, then of course he is entitled to be evicted. You don't want that. You want this court to step in and determine the rent for you, 50,000 per month.
That is correct, my lord. Admittedly, I didn't pray for eviction of the respondents, but my intention was that. So,
I am not
if
convinced of that. Yes, of course you are right. That since they are illegally, they have occupied, they are entitled to be compensated. But how can this court fix that rent for you?
my lord, since no written statement was
And
filed,
there is no evidence shown that what would be the rental amount in that locality for a house, for a land like that. Where are those evidence? On what basis can the compensation be assessed?
my humble opinion is that, my lord, since no written statement was filed and since it was not contested by the respondents, then on the basis of my claim, then decision may kindly be made. Then thereafter, if they aggrieved, then they can file the appeal also. Because it was an ex parte proceeding, my lord. Or if your lordship considers it fit to remand back the matter.
No, this is
Yes.
coming, it is coming
Yes.
into my mind.
Yes, my lord.
Because things appears to be not
Yes.
has come. Yes, Mr. Miller, what do you have to say?
My lord, I would like to say, I have few things to say, my lord.
Yes, please.
So this is my first time
Let me
getting a chance to
get the pulse
actually,
from the other side.
yeah, this is my first time actually getting a chance to elaborate this case
Very well.
on my behalf. So basically, my lord, as they have mentioned that it is an illegal occupation. However, there are so many definitions to illegal occupation which needs a lot of elaboration, because when it comes to illegal occupation, there has to be a few things involved. For instance, there has to be a fake document of some kind, coercion, or any undue influence to gain control of certain property, my lord. So that part is also missing when they define the illegal part, my lord. Yep, when it comes to the certain areas where they have alleged us to be occupants, illegal occupants. But my lord, I would like to mention in this part that the work was initiated in the year 2011-2012. And during this time, this work was not directly obtained by the respondents number 1 and 2. We didn't say that we want to come and work. We didn't say that we're going to come and make the NH 54, but it was allotted to us by the PWD department, my lord. So,
This is what work, Mr. Miller?
Public Works Department, my lord.
What work were you allowed?
National Highway
The
50.
construction of the road.
Yes, yes, my lord. National Highway 54. This is the road between.
And because for construction, land of the plaintiff was occupied.
No, my lord. So I will just get to that, my lord. So it is the construction of the Longklai to Indo-Burma Koladine Road. So this work was given to us by the PWD on a tender basis. And after acquiring the tender, we had placed different materials on the side of the road. It is very common for contractors like us to move accordingly depending upon where we execute the work. We cannot put our raw materials here in Aizawl and work in Long Klang. That's not possible, my lord. So we are always constantly moving as we progress with the work. So I do admit that we don't have a written statement in this civil court. However, I would like to mention that these claims have been, it's purely ex parte, so there's very little I can mention on that part.
You can only submit what is there from records.
Yes, my lord. That's what I'm
travel beyond that.
Yes, I cannot travel beyond that. So I would like to mention that.
See, if you come to page 52 for a minute.
Yes, my lord, I'm here.
And you see four issues were framed. Legally speaking, they are not issues framed.
Yes.
But it is said that to enable an order of declaration, the plaintiff must establish the following four.
Yeah.
Correct?
Yes, my lord.
One is the right of the plaintiff. Two is the infringement.
Yes, ma'am.
And three, infringement, that is the defendant is denying or is interested to deny the plaintiff title to such legal character or right.
Yes, ma'am.
Okay. Three is the declaration, and the declaration sought is that the plaintiff is entitled to such breach character or right. And four is the consequential relief. Now, it appears that this court have said 1, 2, and 3 is in favor.
Yes.
So you see the para 8,
yes.
It is mentioned.
Yes.
2 lines above from the bottom.
Yes, ma'am.
Thus, the plaintiff succeeded in establishing the first 3 conditions. Now, you have not preferred a cross appeal.
Yes, my lord. There's a reason for that, my lord.
You could have.
Yes.
You had the remedies available in law. So, if you wanted,
if I may,
you
my
have
lord.
filed the cross appeal.
Yeah.
However, without doing that now, you are bound by these 3 points which have gone against you. Now from this 3, it appears what is admitted is that you have infringed the right of the plaintiff's title over the subject land.
Yes, ma'am.
This is already admitted.
Yes.
Isn't it? Now the question is, what is the consequential relief to be given?
Yes, ma'am.
That's
the only part.
That's the only part because you have brought it.
Yes, ma'am.
You could have taken recourse to law and
yes.
You could have.
There's so many factors to that, my lord.
Yeah, but
it's not relevant at this point. Yes. Yes.
So you can't really do anything much.
That is why I have not mentioned.
If we come back to this, the consequential relief here, the trial court is in your favor.
Yes.
The trial court says no. There is no rental agreement between the parties. There is no conveyance or any sort of an arrangement between the parties. So where is the question of giving rent?
Yes,
that is the only point on which the trial court says they are not entitled.
Yes.
Correct. Now, the argument from that side is notwithstanding any such agreement, conveyance, the fact that since you are illegally occupying his land, he is entitled to some compensation because the factum of illegal occupation is already admitted. So when you are doing something illegally, he is entitled to some compensation. Isn't it? This is what it is.
Yes, ma'am.
What do you have to say to this?
Yes, my lord. As it is already mentioned a couple of times that
we may go to the evidence. If you want, let us see what evidence was because that part I have not seen.
The evidence part is mainly stressed on the ownership. Yes, my lord. So in this part,
because say for example, because I'm sure you are also an officer of the court.
Yes,
so if an illegal thing has done, of course, it has to be compensated. But now, the thing that is coming to my mind is on what
basis? Yes, ma'am.
There has to be some foundation
yes.
for the claim. Where is that foundation?
That foundation does not exist, my lord.
How can you suddenly give them 50,000 per month?
Yes, unless it has been mentioned prior to the year.
To be there.
Yeah.
Then I don't find.
Yes, my lord. That's non-existent.
We can go back to the evidence. Where is the prosecution witness's evidence? And is the plaintiff
part of the paperwork.
It's in page 41 and 40, yes, 42. So, my lord,
Page?
it's in page 41, 42. It starts from 41, but the main structures is on 42 and 43.
Let's read this one. I will give you a chance to come to argue in the flow. Probably you must have prepared some sort of a flow.
Yes, ma'am.
I'm not going to deny you that opportunity, but let us just understand once from here. This is PW1. Althea, he is the plaintiff.
It seems to be my plaintiff. He's the plaintiff.
All right. Please read.
That I am the plaintiff, number 1, that I am the plaintiff in the instant case. Number 2, that I am allotted a plot of land by the Land Revenue and Settlement Department, LADC, under Section 12 of the Lai Autonomous District Council Land Holding and Settlement Act 2002, bearing LSC number 20 of 2011 of 27/7/2011, covering an area of 50,000 square meters at Bungklang South, thereby providing me all the rights and interests arising out of the said landed property to the effect I duly paid revenue taxes to the concerned authority till date. Number 3, that on date 28/2008, the Land Revenue and Settlement Department, Government of Mizoram, issued notification for acquisition of private lands under Section 4 of the Land Acquisition Act 1894, White Memo, for the construction of the new 2-lane highway for NH54 near Longklai to Indo-Myanmar border in Mizoram to support the Kaladine Multimodal Transit Transport Project Phase 1 under SARDPNE, and subsequently on dated 12/4/2010, a declaration was made under Section 6 of the Act, White Memo, dated 12/4/2010 by the said concerned authority. Accordingly, on dated 24/2010, the Deputy Commissioner Longklai District, White Memo, dated 24/2010, issued notice to the persons interested under Section 9 of the Land Acquisition Act 1894, stating that the government's intention to take possession of the said land and that claims to compensation for all interest in such lands may be made to the concerned authority but my land was excluded from the beneficiaries of the said acquisition. Number 4, that for the execution of the above mentioned project, Mizoram State Government, represented by the Public Works Department, Government of Mizoram, issued notice inviting tender for the construction of the said project under SARDPNE. To this effect, the defendant number 1 and 2 and the Government of Mizoram had signed a contract agreement, MOU, and as such, the Government of Mizoram issued work orders for the execution of the said work in favor of the defendant number 1 and 2. Number 5, that accordingly the defendant number 1 and 2 had stated that the execution of the said work on dated 13/10/2010 by deploying machinery, tools, as well as sufficient manpower. In the course of execution of the said work, the defendant number 1 and 2 started establishing camps and continued to settle within the said land without taking prior possession and consent from me, that is January 2012 till date. That the defendant number 1 and 2 forcefully and illegally occupied 1,400 square meters of the landed property bearing LSC 20 of 2011 of 27/7/2011 out of an area covering 50,000 square meters, and 4 houses including 1 reservoir were also constructed thereon by the defendant number 1 and 2 without prior permission and consent from me. Number 7, that the defendant number 1 and 2 also used my said land for the purpose of depositing and stocking unwanted soil, debris, stones, boulders, pellets, and sand till date, making it unsuitable for agriculture or residential purpose without prior permission and consent from me. Number 8, that as a result of the illegal and forcible occupation of my landed property by the defendant number 1 and 2, I could not utilize and develop the said land, which is my primary source of income, and I have been unreasonably and immensely suffering from the actions of the defendant number 1 and 2 till date. That I personally requested and approached the defendant number 1 and 2 repeatedly and continuously to make a negotiation as well as to pay rental compensation in connection with my said land, but to no avail.
All right, PW2.
PW2, I'll just start from page 47, the first
Yes,
point.
please.
That I am the bona fide citizen. I'll just skip point 1, my lord. Number 2, that I am at present a president of Village Council of Bungklang South 1. That I know the plaintiff personally. Number 4, that I know the plaintiff is a permanent resident of Bungklang South 1. Number 5, that I know that the plaintiff is having a piece of land located at Ramrikon, the village boundary point of Bungklang South and I'm sorry, Ngertlapui village. Sorry. I'm not too familiar with the name either. Sorry. Number 6, that I know that the RDS company is occupying the land of the plaintiff from the year 2012 till date. Number 7, that I know and have seen the RDS company have constructed a camp within this land of the plaintiff. They have constructed 4 houses, including 1 reservoir, since the date of their occupancy till date.
Where is the plaint?
Page 1, my lord.
You filed a written arguments before the trial court, I think. Written arguments on behalf of plaintiff. Sorry. Plaintiff's page?
Page 1.
Page 1?
Yes, my lord.
Yes. Come to paragraph. I think 1 to till paragraph 8 it is about how you have occupied and how you are utilizing. Now come to 9.
Page 3, para number 9. That as a result of the illegal and forceful occupation of the plaintiff's land by the defendant number 1 and 2, the plaintiff could not utilize and develop the said land, which is his primary source of income, and the plaintiff has been unreasonably and immensely suffering from the defendant number 1 and 2's action till date.
Read.
Number 10, that it is pertinent to mention here that the plaintiff personally requested and approached the defendant number 1 and 2 repeatedly and continuously to make a negotiation as well as to pay rental compensation in connection with the said land, but to no avail. That on date 11/9/2020, a legal notice was served to the defendant number 1 and 2 through advocate, directing them to pay notice to pay rental compensation at a rate of rupees 50,000 per month henceforth, and also to pay an arrears amounting to 52 lakhs only with an interest at the rate of 6% per annum, occurring the illegal and forceful occupancy of the plaintiff's land for a period of January 2012 to August 2020, within a period of 30 days from the date of the said legal notice, but to no avail. Number 12, that due to the illegal and forceful occupation of the plaintiff's land.
This is what I have been telling.
Yes. Number 12, that due to the illegal and forceful occupation of the plaintiff's land by the defendant number 1 and 2, the defendant number 1 and 2 deliberately deprives and violates his basic human rights of properties provided under Article 300A of the Indian Constitution, and as such, the defendant number 1 and 2 are liable to pay rental compensation to the plaintiff as per the relevant provisions of the law, along with interest at 9% per annum without any further delay. Number 13, that the cause of action.
Not necessary. Then para 15, it's okay, not necessary. Now come to 18, the reliefs.
Number 18, that the plaintiff, 18C, to pass an order directing the defendant number 1 and 2 to pay rental compensation at the rate of 50,000 per month henceforth, and also to pay the arrears amounting to rupees 54 lakhs and 50,000 only with an interest at the rate of 6%, occurring from the illegal and forceful occupation of the plaintiff's land.
Yes. See, you have not filed a WS. You did not contest the suit. Now these averments made in the plaint, tense admitted. There is no contest. The trial court has given a verdict that yes, you have been illegally occupying his land. If that is the verdict, the consequence of that verdict ought to have been compensated, ought to have been a decree for compensating the plaintiff, and that he has already claimed that this is his loss, and so it should be given. You have not.
Yes, my lord.
So there is no question for him to make any further foundation. The court ought to have given whatever is asked, because you have not contested.
Yes,
That's
my lord.
what.
Yes.
Isn't it? Which is that written statement, no specific denial, order 7 or order 8? Order 8. Non-denial amounts to admission of facts. Written statement, order 8, rule 1. Sorry, Mr. Miller,
Yes, my lord.
I don't think you have a case. Yes, I think
Order 8 Rule 5.2 is relevant, my lord. I think your lordship. Order 8 Rule 5.2.
order 852.
Yes, Order 8 Rule 5.2. It shall be lawful to pronounce judgment on the basis of the facts contained in the plaint.
One second, order 8.
Rule 5, subclause 2.
Order 8, rule 5.
Yes, Rule 5, subclause 2.
Yes.
Pronouncement on the basis of the facts contained in the plaint.
Where the defendant has not filed a pleading,
Yes.
it shall be lawful for the court to pronounce judgment on the basis of the facts contained in the plaint, except as against a person as well.
Yes.
Yes.
Yes, since it's an ex parte order, my lord, there's very little that I can say. I think that is.
All right, let
Not
me
much
make
I
an
can say.
attempt. Let me make a start. Let's see how long. But Mr. Lalram Enga, right?
B. Laramega.
So and so, learned counsel for the appellant. Also heard Mr. Miller Bikrimpui.
Yep.
Bikrimpui.
Yes. Yes, my lord.
Bikrimpui.
Yes, my lord.
Correct.
Yes.
Bikrimpui. Learned counsel for the respondent.
1 and 2.
For the respondent numbers 1 and 2. The present RFA, or regular first appeal, is presented against the. Yes, counsels, take your seat. Against the judgment and order dated 18/11/2022, passed by the learned senior civil judge, Launtlai, Mizoram. In civil suit number 1 of 2021. By the aforesaid judgment and order dated 18/11/2022, the civil suit number 1 of 2021 filed by the appellant was dismissed. The facts of the case is that the appellant filed the civil suit number 1 of 2021, wherein he made a claim against the respondent numbers 1 and 2 for payment of rental compensation at the rate of rupees 50,000 per month from the date of filing of the suit, and also for payment of the arrears of the rent amounting to rupees 54,50,000 with an interest at the rate of 6% per annum with effect from January 2012 due to the illegal and forceful occupation of his land covered by LSC number 20/2011, covering an by its order dated 22/11/2021. Stop. However, despite the appellant having proved his case by adducing evidences, it is the specific case of the appellant that the trial court has dismissed the suit. Stop. Situated thus, the present regular first appeal has been preferred by the appellant. Stop. Mr. So-and-so submits that the judgment and order of the trial court is manifestly and palpably erroneous, inasmuch as, despite having come to the finding that the respondents are illegally occupying the land of the petitioner plaintiff, dismiss the suit and rejected the relief of rental compensation as claimed by the plaintiff in the said suit. Stop. He further submits that the suit having proceeded ex parte, and there being no written statement filed on behalf of the defendants, the trial court ought to have pronounced judgment on the basis of the facts contained in the plaint. submit that despite the suit having proceeded ex parte, the trial court called the plaintiff to adduce evidence to prove his case, instead of pronouncing the judgment on the facts pleaded, and hence has committed manifest error by not following the procedure laid down in Order 8 Rule 10 of the CPC. Yes. Stop. Next one. Per contra, Mr. Miller, so-and-so, learned counsel for the respondent submit that there is no infirmity or irregularity whatsoever in the judgment and order of the trial court, and hence the appeal is not, hence no interference, hence the impugned judgment in the appeal warrants no interference from this court, from this appellate court. Stop. He further submits that the plaintiff has not adduced any evidence to show that the plaintiff is entitled for any compensation as claimed from the respondents. Stop. Anything else? I have given my prudent consideration to the arguments advanced by the learned counsel appearing on behalf of both the parties, and have perused the materials available on record, including the case records. Stop. Yes.
I'm representing number 1 and 2, my lord.
Or is it? And in the beginning, Mr. Miller for respondent number 1 and 2, and Ms. MS Carolina, right? For respondent number 3. R3. And after the submissions of Mr. Miller, and before I said I have given my prudent consideration, there you say MS Carolina, learned counsel for respondent numbers. The state respondent. Yes. Anything you want to say? No, I have nothing to say. Submits that she has received no instructions in the appeal. Stop. Right. It appears that the land of the petitioner, in bracket LSC number 20/2011, so?
20 of 11, 2011.
Was occupied by the defendant, by the respondent number 1 and 2 during the construction of a new 2-lane highway from NH 54 near Longklai to Indo-Myanmar border in Mizoram for the purpose of depositing and stocking unwanted soil, debris, stones, boulder, pellet and sand till the time of filing the suit thereby disallowing thereby dispossessing the plaintiff to enjoy the said land to utilize the said land, utilize and develop the said land, which is alleged to be his primary source of income. Stop. Paragraph 3 to 18 of the plaint is reproduced hereunder for ready reference. Page 2, page 2 of the paper book. A to A. It appears that though notices were issued to the respondents on several occasions and were duly served upon them, the respondents did not appear in the court nor were represented by any counsel. Stop. It further appears that thereafter the case proceeded ex parte on 22/11/2021. Stop. It further appears that the appellant stroke plaintiff was called upon to adduce evidence in support of his claim, and the plaintiff appellant accordingly adduced the evidence of 2 witnesses including himself. So, upon completion of the arguments on behalf of the petitioner, on behalf of the plaintiff appellant, the trial court held that to enable an order of declaration, the plaintiff must establish the following. 1, 2, 3, 4, page 52 of the paper book. B to B. Thereafter, it appears that the trial court has held that the plaintiff appellant succeeded in establishing the first 3 conditions, i.e., infringement by the respondent 1 and 2 in denying the plaintiff his title over the subject land. Stop. However, the trial court finally came to the finding that since there is no documentary proof of any rental agreement or other deals between the plaintiff appellant and the respondent number 1 and 2, therefore the plaintiff appellant is not entitled for any rental compensation as claimed for. Stop. Upon in view of the above, the following points arises for determination. 1. Whether the plaintiff appellant is entitled for rental compensation from the respondent number 1 and 2 for illegally and forcefully utilizing the subject land of the plaintiff. Number 2, whether the averments in support of the rental compensation set up by the plaintiff appellant in the plaint be accepted for determining the rental compensation in the absence of any pleadings on behalf of the respondents. I think this too. Next. I'll do one thing. Let this be typed. I'll post the matter on Monday. I may finish the rest of the judgment, or otherwise I'll complete it on that day. All right?
My lord.
So, arguments completed, list on Mondays for delivery of judgment.
I'll oblige.
Other one is there.
My lord,
Yes.
As it is, I'm not feeling very well today. Lots of coughing and if we can,
Yes.
already 4:30, so we can do it on Tuesday.
Yes, no problem. Mr. Silo, right?
Yes.
My lord, may I interrupt one? This matter was listed on 22.8 and none appeared for the appellant. And for the interest of justice, it was listed again on 27.8.
Today,
And
Mr.
time
Silo
was-
is there, and it's already 4:30.
My lord,
There's only going to be 15 minutes. So I don't think there is any point for starting the hearing, but you give me a date on the next day. Next week?
Tuesday?
Lordship, I have
Give
some
me-
personal difficulty in Tuesday, my lord.
When do you want it?
It may
Wednesday be fine.
Wednesday?
become on Thursday, my lord. Thursday,
Thursday?
my lord.
As prayed for by, no, you said due to paucity of time, the hearing could not be taken up. List again on such and such date. Give me a date.
Nice.